So it gets a little weird sometimes, and that's a circumstance I'd like to bring up to you because it touches on some of the stuff that I addressed yesterday. One case, it's not even a case. You know Janus.
Yes.
Okay? Let's describe this as the Janus saga because it's more than really one case. And it's really about a completely different case called Abood. You're familiar with the Abood decision.
Yes.
So the Abood decision was precedent for what, 40 years?
I can't remember when Abood was decided, but it was precedent before Janus.
Yeah, and roughly 40 years, I'll tell you. And had repeatedly been reaffirmed.
It was a longstanding precedent.
Yeah, on which there was considerable reliance.
Let's see. So Janus did overrule that precedent, and so Janus did go through the application of the stare decisis factors in deciding whether to overrule it,
Right.
whether that
And there was in fact reliance in the 40 years that it had been the law of the land on the question of the union question that it had resolved.
Well, I don't want to second guess or criticize or praise the majority in Janus's
I'm not asking you to. I'm
calculation.
asking you, as a matter of fact, had 20 plus states relied on it?
Well, Senator, I think reliance and the degree of reliance on Abood
Okay.
is a legal question.
We'll just leave that then. So the Janus saga begins actually with a case called Knox, in which Justice Alito took a shot at Abood. He criticized it as substantially impinging upon First Amendment rights of union members. For people who are watching, the Abood case was about the right of a labor union to get compensated, not dues, but just compensation from non-members when in their representation of their members they get added benefits for the people who are not members. So not the most exciting part of the law, but settled this question of when labor unions could get compensated for work they do for non-members. But Justice Alito did not like it. He took a shot at it in Knox versus SEIU, and the concurrence in that case said, whoa, wait a minute. Quote, the majority's choice to reach an issue not presented by the parties, briefed or argued, disregards our rules. But Justice Alito didn't like something about Abood, and so he took that shot. Then we went on to a later decision called Harris v. Quinn. Alito took another shot at Abood in that case, describing Abood as having analysis that is questionable. He undertook an extended critique of the decision, describing it as having questionable foundations. Justice Kagan spotted that, and in her dissent, she said, today's majority cannot resist taking potshots at Abood, and described its critique of Abood's foundations as gratuitous dicta. But the message went out from Judge Alito that he wanted to do something about Abood. There was something about Abood that he did not like. And with that, we went to, that's the prequel. Then we went to the two cases that followed. The first one was Friedrichs, which was supposed to be the case that got rid of Abood. And it had an interesting travel because the lawyer in the case was one of these groups from Janus. It was the Center for Individual Rights right here, who was counsel. In Janus, the National Right to Work Legal Defense Foundation was counsel. So they switched, right? In Friedrichs, Center for Individual Rights was counsel, National Right to Work was an amicus. When it went on to Janus, they switched. National Right to Work Legal Foundation, Defense Foundation was counsel, and Center for Individual Rights was an amicus. And from everything that I see, it looks like they actually went out and found the plaintiff. So back to our earlier discussion, it wasn't the injured person that went and hired a lawyer. It was the legal group that went and found a plaintiff. And then they went to court, which everybody does, but it got interesting there because there the lawyers asked to lose. I don't know if you've ever been in a case in which the lawyers asked to lose before. I never have been. I've never litigated against anybody who asked to lose. Have you ever been in a case in which a party asked to lose?
No, I don't think I've ever experienced that.
Yeah, I can I can imagine not. So these groups with all this money behind them from Donors Trust and Bradley Foundation and all come into court and they say, please dismiss my case in the district court. Then they go up to the Ninth Circuit and they specifically ask the Ninth Circuit to get rid of their case, to uphold the decision dismissing their case, quote, as quickly as practicable and without argument. Have you ever seen a case in your circuit where somebody came in and said, I'd like to lose, and I'd like to lose as quickly as practicable, and I'd like to lose without making an argument on behalf of my client?
But Abood was controlling law at that point, right?
My question was, have you ever seen that happen in your circuit?
I have not seen that happen in my circuit.
Yeah. Okay. So then the case went on to decision, and as predicted or signaled by Justice Alito, it looked like it was going to be a 5-4 decision knocking out Abood after 40 years. Sadly and unfortunately, Justice Scalia died before that decision could be rendered, so it actually turned out to be a 4-4 decision. And as you know, a 4-4 decision, the tie goes to the decision below, and the Ninth Circuit prevailed, and so that was it for Friedrichs. But it didn't take long for this same group. So this is back to my Janus exhibit. These are all the commonly funded amici and lawyers who showed up in Janus. 11 of them had showed up in Friedrichs. So Janus was a reunion of the team, everybody piling back in together to get what they, and there was no big rush this time, because this time they had to wait for the vacancy on the court to be filled. They didn't want a 4-4 decision. They had to wait for Justice Gorsuch. So there wasn't the same rush. The case came through more ordinary travel, and then, boom, in they went to argue it, and down came the decision. And I ask you to think that through, because I've done some appellate argument, and I've done some trial work, and I have run an awful lot of litigation. And one of the things that has been a constant for me has been the belief that even if I was kind of taking a long shot case, I'd get a fair hearing, I'd get a fair decision, and I had a shot. I've got a feeling that the lawyers going into the United States Supreme Court in that Janus case, looking at this array of commonly funded anti-union front groups assembled against them as amici, having seen what Friedrichs portended, having been signaled by Alito in those earlier cases that they wanted to get rid of Abood, that they was on the hunt for Abood, that's a feeling that no lawyer should have in America. And all I want to do is leave with you the thought that when you're on the court, I hope you will conduct yourself and see in whatever way you can that the court conducts itself in such a way that no lawyer goes into an argument in the United States Supreme Court feeling that the case is set against them and there's nothing to be done other than go in and take your medicine.